5 seconds to go. Start. From the record of the disciplinary proceedings, it emanates that the petitioner has written an application dated 1st December 2001 to the inquiry officer, requesting therein to supply the copies of the statement recorded, if any, during the course of inquiry. On this application, there is an order of the inquiry officer to the senior administrative officer to supply copies of the documents on deposit of requisite fee so that he may submit his written reply in time, but there is no document to show that the documents so demanded were actually supplied to him. On 3rd December 2001, the petitioner again wrote an application to the inquiry officer demanding 13 documents, details of which is given in clear words in the said application. There is an application dated 15th January 2002 of the petitioner on record, in which petitioner has requested to keep the inquiry proceedings in abeyance as he has given a representation to the High Court for transfer of inquiry to some other district. There is no order on the said application. There is another application dated 22nd January 2002 written by the petitioner to the inquiry officer demanding certain documents, apparently that too were not supplied to enable him to put his version effectively. Moreover, the petitioner had indicated the relevancy of the documents so demanded by him. Similar request was made via applications dated 2nd February 2002 and 8th February 2002 and 28th February 2002. There is nothing on record to show that at any point of time the inquiry officer had observed that the documents demanded by the petitioner are not relevant or the witnesses whom the petitioner wants to examine are not relevant. On the contrary, there is admission of the opposite parties that the petitioner had demanded the documents. Mere saying that the documents were supplied to the petitioner would not absolve the responsibility of the opposite parties. There is no documentary evidence letter to prove that the documents so demanded by the petitioner were supplied through a letter. It may be added that the stand taken in paragraph 14 of the counter affidavit is contrary to the record produced by the respondents. It may be added that in the charge sheet, the primary charge against the petitioner is that during preliminary inquiry it was found that a racket is operating for filing fake claim petitions on fictitious names with fake documents, and petitioner is also involved in filing the fictitious claim petitions with the aid of certain clerks and advocates. A perusal of the inquiry report reveals that the inquiry officer did not examine any witness to prove the charges levelled against the petitioner, and only on the ground that there is no denial by the petitioner it has been held that he was involved in the racket and recorded that both the charges proved. There must be clinching evidence to connect the delinquent employee with the charges levelled against him. It was the pious duty of the inquiry officer to ascertain the truth, being the independent investigator, as to how and in what manner the petitioner is involved in racket. Stop.